Hi everyone, I'm Ross McRae, Group HR Director and Deputy MD at the Ryan Group. Welcome to our presentation series on off-payroll working. This is number 4 in the series, and in this presentation we'll have a look at what changes in the private sector when the impending IR35 legislative adaptions are applied in April 2020. So what do we know about the proposed changes? You may not know that the majority of the changes have actually already been applied to the public sector back in 2017. They were scheduled to be implemented in the private sector in April 2019, but the government delayed the implementation by 12 months to allow more time for private businesses to put in place appropriate arrangements. The public sector changes became visible in the press for a variety of reasons, including the level of unpreparedness for the changes, HMRC actions against high-profile contractors working for the likes of the BBC, and attempted blanket bans on engaging contractors by public bodies such as the NHS to avoid the changes altogether. It's fair to say that there remains a high degree of challenge regarding engaging self-employed workers in the public sector, and matters have not completely settled down, with some bodies reversing their initial blanket bans, others still to conclude adjustment implementation processes, and others having done little and therefore accruing risk to their organisation. Before we look at what's changing, I'll quickly go through the timeline as it is just now. In mid-January 2020, a further review of the rules were announced. In early February, we should see further guidance and the draft statutory instrument released. By mid-February 2020, the review will have concluded and will presumably be quickly assessed, with revisions added to the final legislation, which is due for publication in mid-March. Then on the 6th of April, the legislation goes live. So what's changing? Well, briefly, personal service companies lose the right to decide their own IR35 status. The responsibility for determining whether a contracting worker is regarded as an employee, if they were directly engaged for tax purposes, transfers from the personal service company, the contractor, to the engager, i.e. the end client. The client, or more likely the agency paying the contractor, is then responsible for deducting the income tax and national insurance and paying them to the revenue where required. The liability for paying employers' national insurance therefore also transfers from the contractor to the end client or the fee payer agency, along with other responsibilities such as paying the apprenticeship levy. You can therefore see why this has caused a lot of challenge and confusion in the public sector, as many end users are not familiar with IR35 and will clearly struggle to determine the employment status of contracted workers. You should note that the off-payroll rules only apply for personal service companies with medium to large size clients. If the end user is a small business, they may still be captured though, if they have a larger parent company or a joint venture partner. A small company is classed as one that meets 2 or more of the following criteria: less than 10.2 million turnover, balance sheet of less than 5.1 million, or less than 50 staff. There are some additional rules that have been added to the legislation. Of particular importance is the requirement for a status determination statement, or SDS as it's typically called. That's to be provided to subcontractors, though there's little clarity on what should be detailed in the SDS. There's also a responsibility for the end user of contractor services to take reasonable care when determining a status outcome. It's argued that making a blanket decision that all workers are either in or out of scope of IR35 is not taking reasonable care. Now, it's likely that we'll see case law determine what is or not appropriate with regard to blanket decisions. Implementing a consistent, detailed assessment process that provides a documented outcome should meet both reasonable care and the SDS requirements. Now, regardless of whether an end user has outsourced their IR35 assessment process to a third party or are undertaking it themselves, They are responsible for ensuring that the IR35 status of each contract worker's assignment is notified to the next party in the supply chain, along with, as we've established, the reasons for the decision. It's important to understand that the changes may come into effect on the 6th of April 2020, but the rules will apply to all payments made on or after the 6th of April. So, for example, a subcontractor that is paid on a monthly basis in arrears may have their March 2020 income affected. A further consideration for end users is that they're obliged to put in place a status disagreement process, which is effectively an appeal process. This needs to address any disagreements about status decisions that have been taken. The end client must respond to the appeal within 45 days, and they should ensure that they inform the worker or the deemed employer that has considered the appeal and decided that its original SDS is correct and the reasons for that decision, or they need to provide a new SDS with a different decision confirming that the previous SDS has been withdrawn. Now, if the client doesn't respond within 45 days, it will then be deemed to be the fee payer, and the liability passes from the agent to the end user. There are no limits on how many times an appeal can be made, and there's no advice as yet regarding what should happen should a status determination disagreement remain unresolved. You can see that further clarification is required in relation to some of the documented changes. The revenue also have other challenges, primary of which is that the contracting community has little confidence in the revenue's assessment ability, and many commentators observe that the forthcoming changes do not address existing IR35 problems dating back 20 years. HMRC's track record at tax tribunals since 2000 supports this view, with only around half being awarded in their favour. It does not, of course, take into account the number of cases that are settled outside of court. Other potential problems relate to blanket bans, what happens to contractors with incorrect IR35 status assessments, and the much maligned check employment status for tax tool. The CESS tool, or the Check Employment Status for Tax tool, is a system that the government developed to assist businesses assess employment status. The service is effectively a series of questions online that leads you to intermediate legislation does or doesn't apply response. There's actually also an undetermined response too. And whilst it's not mandatory, the Revenue placed considerable reliance on the CESS tool to help administer the rules. HMRC state that they stand by CESS decisions, but admit that it does not assess all cases. The fact that its results have been contradicted in court findings have not helped, and has fueled the need for clients really to prepare their own solutions. So the Revenue may argue that tax receipts are up, but there's currently no evidence that IR35 compliance has improved. A further challenge relating to the new IR35 legislation is that the change does not introduce employment rights to the individuals captured by IR35 if they remain engaged through the personal service company. Even if the revenue liability flowcharts have been challenged, they are still unclear and difficult to interpret. We are now seeing some contractors being told to transfer to a PAYE model, accept a staff role, move to an umbrella company, or effectively leave the end user that they're providing services to, which is clearly causing administration and resourcing issues. At this point, it's worth noting due diligence, and that there are non-compliant umbrella and other models out there that should be avoided. We'll cover engagement models in more detail later in the final presentation in our IR35 series. Despite these challenges, however, the government has confirmed that the IR35 changes in April 2020 are proceeding. Okay, that's it for the changes due in April 2020. Our next presentation in our IR35 series looks at the end user's new responsibilities, some of which I've just covered and others that we'll go into in greater detail. Thank you.